Now, shall we go to our next guest? She's not a lawyer, so let's hope that she doesn't introduce us to too much legalese. Bridgette Dzogbenuku is the founder, executive director of Mentoring Women Ghana, an organization born from her belief that women in leadership make economic and developmental sense. For 12 years, she was the first general manager of Aviation Social Center, a fitness and recreational center in Accra, where she introduced various innovative fitness programs and events into this niche industry in Ghana. Bridgette is a fellow of the Vital Voices Leadership Network and has participated in various Vital Voices leadership training programs, including the Fortune U.S. State Department Global Women's Mentoring Partnership 2008, V-Lead 2014, and VV Engage 2019. She won the 2008 Fortune Goldman Sachs Global Women's Leadership Award. Bridgette ran for political office as the running mate, vice presidential candidate, to the flag bearer of the Progressive People's Party in Ghana's 2016 general elections as presidential candidate in Ghana's general election, and she was the presidential candidate substantive in the 2020 elections. You must have heard her before, and she believes that a lot has to change in the Constitution. Bridgette, thank you very much. Let's hear you in the next 15 to 20 minutes, and then we'll ask our questions.
Yeah, thanks. I am having issues hearing you, so
we can hear you clearly. We can hear you clearly
and see me. That one. Oh, I can't hear you at all, but I'm going to assume that I can be heard and be seen. And I would like to say thank you very much for this opportunity to join you once again on the Joy Change Speaker Series, and once again to touch on the subject of the need for a constitutional review, which is gradually gaining traction and relevance in our country. I thank you for acknowledging that this message that my party, the Progressive People's Party, has harped on in the last 10 years of its existence. Indeed, it's been in existence for 10 years. And the message for the need of constitutional amendment has started to hit home and resound with many of us Ghanaians. I would like to mention that my delivery this morning is a collaborative effort of many of the members of the Progressive People's Party over the years. The ideals with which I identified and therefore chose to join as a vice presidential candidate in 2016. Indeed, portions of this delivery have been presented at a recent IEA program. It is worth mentioning that no other political party in Ghana has remained so resolute, committed, consistent, and vocal on the subject matter of the constitutional review in Ghana as we have. We made representations to the Constitutional Review Commission, Constitutional Review Implementation Committee, the Presidency, Parliament, and the Council of State on these matters. It would therefore seem that successive elected governments have demonstrated a clear and present lack of political will to make necessary changes to our 1992 Constitution. Until now, that I can see, the majority leader was just talking about it. The president said something to the effect in the clip that you showed. But as someone from one of the major parties said to to preside over their own demise. That this is how the two major parties, or the parties that have been in government, have thought about it. That in the exercise of our natural and inalienable rights to which shall secure for ourselves and posterity the blessing of liberty, stress mind, equality of opportunity, and prosperity, in the spirit of friendship and peace with all peoples of the world, and in solemn declaration and affirmation of our commitment to freedom, justice, probity, and accountability. The principle that all powers of government spring from the sovereign will of the people. The principle of universal adult suffrage, the rule of law, the protection and preservation of fundamental human rights and freedoms, unity and stability for clearly the essential elements which constitute our aspirations from the preamble include blessings of liberty, equal opportunity, prosperity for the people, freedom and justice, probity and accountability, universal adult suffrage, and the stability of our great nation. It is evident that after 3 solid decades of operating this document, several of the aspirations have eluded the good people of Ghana. The state of affairs now. Our country is yet to derive the dividends of democratic governance, and I think I heard the other day that the president of Zambia was also saying the same. The conduct of peaceful elections and the successive transfer of power have been used as an indicator of success of our democracy, without evaluating the actual improvement in the lives of the people. And that makes me look at the title of your program today, which says, "If you do democracy, we go chop." So there's without evaluating the improvements in the lives of the people in the area of education for every citizen, access to basic social amenities such as water, electricity, affordable housing, infrastructural development, housing, jobs for the youth, political accountability, reduction in corruption, and economic stability. What we have to show for 30 years of democratic governance is massive levels of youth unemployment, excessive powers of the executive arm of government, as your previous speaker said, Alhaji Inusa, a grossly compromised parliament, abuse of power, unbridled corruption, waste of Ghana's resources, nepotism, mediocrity, mismanagement of the economy, and the constant failure of leadership. In fact, the current constitution, in our view, has created a situation where the winning political parties have treated the republic as a colony to be conquered, and its resources taken for the welfare of a privileged few members of the party in power, making subjects of the citizenry making subjects of the citizenry and depriving most Ghanaians the dividends of the well-constituted democratic state. The stability of the country is therefore threatened by sheer greed, elite capture, and an intensely exclusionary political system, where citizenship is no longer enough of a requirement to have access to state resources and to partake in the sharing of the national cake. A citizen must necessarily require membership of the party in power to benefit from the welfare of the state. So the winner takes all 1992 constitution cannot sustain a democracy beyond the near future, and therefore the urgent need to implement the following fundamental constitutional amendments. I will focus on 5 fundamental changes that need immediate attention to guarantee some progress if Ghana is to gain or get any dividends in our last democratic experiment. For us in the PPP, we are choosing the 5 areas, not necessarily for a complete review of 1,000-page documents, although we agree that there are many other areas that need amendments, and the previous speaker mentioned a few of those. We believe that these 5 are critical to start a progressive development, to start, as he said, a progressive development trajectory at all levels in our governance. These include: 1, returning power to the people for all Ghanaians to directly elect their district's municipal and metropolitan chief executives without any interference of their operations from the president, and cancelling government appointees to the district assemblies. 2, prohibit members of parliament from being appointed as ministers of state. All MPs must resign from parliament when they are appointed as ministers. And I think the majority speaker mentioned that in the previous clip that you showed. 3, strengthen the office of the Attorney General by separating it from the Ministry of Justice. 4, introduce a public declaration assets regime. And your previous speaker and I have been in a forum where we've actually spoken about that before. And 5, clarify the eligibility of Ghanaians in the diaspora to hold public office. Let's talk first about the number 1, MMDCs. It will be superfluous to recount the benefits of electing directly and by universal adult suffrage municipal and district chief executives, the district assemblies. We would like to emphasize that the concept of government appointees should also be completely abolished. Government appointees to the district assemblies, yes, with elected government.
Its feed has not been the best. The network keeps breaking. Hope that we get a better connection to her shortly.
Past legislation have now arrogated to themselves the role of development agents with no constitutionally allocated resources. The result is that MPs resort to all kinds of unorthodox ways and policy violations to attempt to bring some development to the people. You see, as the previous speaker was saying, or the majority speaker in the clip you showed, because the MPs whose job it is to pass legislation have arrogated themselves the role of development agents, their budgets for their campaigns are bloated. And this, if we allow ourselves, if we are let to vote for our own MMDCs and DCs, would actually lessen their burden of the country.
He's making some really far-reaching recommendations for far-reaching changes there. Of course, some of what he says coincide with what our previous speakers are saying. We're hoping that her network stabilizes. We're trying to reconnect with her on a connection that we suspect should be a lot more reliable. But as you say, as you heard there, she's elected, and this position, she says, is that of the Progressive People's Party, which she has been vice presidential candidate and also presidential candidate. Election of DC is important to them. Separation of the Attorney General, you know, which has been a debate that has gone on for quite a while. Asset declaration regime, diaspora vote, clarity that is required. So please proceed with your presentation. Hello, Bridgette. Did we lose her on the line? Okay, we just lost her, so we'll re-establish contact with her so she can complete her presentation. Remember, we have Professor Bafo Ajimandua, governance, person par excellence, to also make his delivery and take some questions from you and from us. We also have Ace Anan Ankoma, You have heard him write recently, amending the Constitution we deserve. All right. Thank you very much. I hope your line is better now. Please proceed.
I hope you can hear me.
Yes, we can. Did we lose her again? Okay, it does appear we lost her again. So this is Newsfile. It is your special edition, and this is your Joy Change Speakers Forum, and this is 4th edition. We are focusing on Constitution review on the 30th anniversary of the Constitution of Ghana. Please, let's hear you continue with your presentation.
That would be me, Samson, I believe.
Yes, please go ahead.
Okay. And I wonder where you lost me, so I'll try and... So I was talking about the voting of the MMDCs and the fact that the MPs arrogate the role of development agents to themselves. But the office of the chief executive has instead become a trophy to be won and hijacked by elected political parties to reward party members who could neither become MPs nor ministers of state. Interestingly, while the MMDC elections are supposedly not partisan, we have seen general secretaries of ruling parties traveling around the country to conduct a so-called vetting of applicants, mostly foot soldiers who have applied to become MMDCs. The political party has become a substitute for the established Public Services Commission, as your previous speaker said, for the vetting and appointment of candidates to occupy public office. And this is happening because we have a winner-takes-all executive, which must ensure that all MMDCs are party members who deserve the position and indeed will toe the line of the party. The devolution of power in the election of the district chief executive remains a democratic deficit and a major impediment in the development of the various smaller units that constitute Ghana. Elected officials will demand their resources allocated by the Constitution through the District Assembly Common Fund without fear or favor, and will receive them promptly for local development. Currently, the center, which is the government, solely determines whether the assemblies need machetes or Wellington boots, for example, and choose to use part of their allocated budget to procure these items to be sent to the district. Most often than not, these items are useless to the assemblies who cannot complain for fear of removal. The appointed authority has effectively denied them the funds the districts actually need. An elected DCE can demand and possibly sue the central government to demand full payment of the allocated funds when the DCE is accountable to his electorate and knows he will be voted out if he doesn't act. Elections of MMDCs will ensure local accountability, elimination of corruption, and rapid development. Indeed, if citizens can elect the president, who is almost far removed from them in Accra, and members of parliament, they should be credited with the wisdom to decide who governs them at the local level. A couple of years ago, there was a supposed attempt to do this. However, it would seem that there was no real political will, else the necessary amendments would have happened without the national drama we witnessed, which led to the suspension of the well-publicized referendum. It was suspended apparently because there was no consensus according to an official statement. But how else could we have ensured whether there was consensus without allowing the people to vote on that question? Whose consensus was sought? In our view, the question of the MMDCs the question of whether MMDCs should be elected on partisan basis, which triggered the referendum, was not necessary at all. We can elect our chief executives tomorrow if Parliament decides that it is necessary, it is making the necessary amendments without going for a referendum today. All that we need to do now is for Parliament to amend the Articles 242D, which deals with the appointment of the 1/3 of Assembly members, and Articles 2431 and 2433, which deals with the appointment and disappointment, if you like, of the chief executive. These are non-entrenched provisions in the Constitution. Both the NDC and NPP are very much aware, but both parties stand to benefit from appointing MMDCs to the detriment of the people. So they choose to go through a referendum to deny Ghanaians their rights. As I said, someone said to me, no one wants to preside over their own demise, indeed. The question of the partisan election arises under Article 55.3. This article does not in any way deal with whether an MMDC can be elected or appointed. It only prohibits political parties from participating in district level elections. So it's our view that we can start electing MMDCs now and allow the process to run for some time. Then we can look at whether political parties should be allowed to participate or not in the future. As we say, water finds its own level. The people and the results will begin to show after 2 successive elections. Our second point on the constitutional amendments is to separate MPs from ministers, so amending Article 78(1). The need for strict separation of powers cannot be overemphasized, and I believe that also was said by the majority leader in the clip you showed. Since the current arrangements where the 1992 Constitution, by design, bequeathed Parliament to the executive, and has hampered Parliament's ability to exact accountability from the executive on behalf of the people. Article 78(1) mandates the President to appoint majority of his ministers from Parliament. This means that more than half of the ministers and deputy ministers must be members of Parliament. Every member of Parliament in the ruling party therefore hopes to make the President's honor roll for a ministerial appointment. Checking the government against malfeasance cannot therefore be their priority. Besides ministerial appointments, some members of Parliament are also appointed as board chairs and members of boards of directors of state-owned enterprises, corporations, and other institutions, thereby compromising the supervisory role of Parliament. This has resulted in a compromised Parliament, which is obviously ineffective in scrutinizing the activities of the executive to guarantee the judicious application of the nation's resources. One of the many reasons why the fight against corruption has been very difficult for Ghana. The phenomenon of appointing ministers from within Parliament invariably denies Parliament of the very useful human resources and the role for which the MP himself ran for office. Given the option to choose his ministers from beyond Parliament, the President will have the opportunity to choose from the rich Ghanaian brains and the expertise to work with, whilst the elected legislature do their work of scrutinizing the executive. According to Professor Michael Quay, the immediate past Speaker of Parliament, the power of the executive is so much that it determines the seating arrangement in Parliament. How can this be? The separation of powers will take the hands of the executive from Parliament completely. It is our position that if a member of Parliament is appointed as a minister or accepts any other appointment by the President, then he must resign his seat before taking up the appointment. People who seek to become public officers must choose to either become part of the legislature or the executive to avoid conflicts of interest. Our third point is the Attorney General. Amend Article 88. Article 88 of the Constitution should be amended to separate the Attorney General from the Minister of Justice, or more specifically, the Attorney General must not be a Minister of State, nor a member of the government. We believe that making the Attorney General a Minister of State compromises his or her ability to fight and prosecute political corruption cases, for example. The failure of the Special Prosecutor's Office and its lack of independence is clear to all of us now. What we need to fight political corruption effectively is the immediate establishment of an independent Public Prosecutor's Office separate from the Minister of Justice. This is the only way to realistically fight corruption. So we are calling for a truly independent Attorney General, that is, an independent public prosecutor, whose budget will be sanctioned by Parliament without any ministerial interference. It is evident from our past experience that it will be fruitless to leave the fight against corruption in the hands of an elected government and its appointees. For this reason, we propose that the Independent Public Prosecutor, IPP, should be elected directly by the people to check the government against political corruption. The People's Prosecutor will be elected on a different electoral cycle, preferably during the midterm of an elected government. The Independent Public Prosecutor will be given all the vast prosecutorial powers with guaranteed tenure of office, independence, and adequate funding directly from Parliament to go after corrupt government officials. The government's own lawyer then will be the Minister of Justice under this proposal. Can we imagine if someone like Martin Amidu got elected and had direct funding from Parliament to do his work without any ministerial interference? Our next point is the Public Declaration of Assets. Amend Article 2861 and 2863.
On one of your last two issues,
Yes.
a minute.
I'm sorry. Yeah, I have a minute to go.
That is so.
Okay. So, Public Declaration of Assets. We continue to hide Declaration of Assets, the documents for the Declaration of Assets, in an envelope. We put it in an envelope, it's sealed, and it's presented. We are saying that every public official, anybody who is appointed into public office, must openly declare their assets. It must be published, and the public must have access to it, so that we know how their assets are. We can compare when they are out of office or when they are going out of office. The last point is Ghanaians in the diaspora. We have many Ghanaians in the diaspora who are contributing to our economy on a very large scale. We have many Ghanaians in the diaspora who are skilled, who are experienced, who have brains, and we must amend Article 94 to or clarify it so that they can vote. We must not make people, we must give our Ghanaians in the diaspora citizenship over their dual citizenship.
All right.
The fact that they are dual citizens cannot make does not make them unable to be full citizens.
All right. Thank you. Thank you
So
thank you.
We declared it on December 7, 2021. We declared it as a Fix the Constitution Day. It is Constitution Day. We are saying hashtag Fix the Constitution Day. Each 7th December 2021, let's go and see what else we can amend on this Constitution. As
All
we
right.
say, it's a living document.
Okay.
And it must
Thank
continuously
you.
be.
Thank you so very much, Bridgette Dzogbenuku. And I'll invite our guest, if you can, time yourself, so that at least when you are at the 15th minute, you would know how to end. So I reserve my questioning. I suppose Mami may have one or two things but not a question. Mami, you want to make a brief comment before we proceed to take a break and then bring our other guest?
Yes, I do. I think some of the some of the points that the PPP through Bridgette raises are very valid, and it seems that we are all agreed on the overlap between the legislature and the executive. And as far back as President Kufuor's time, even President Kufuor himself complained that it makes them inefficient ministers, but also makes them inefficient MPs. And so while the committee meant well with this hybrid system, my position has always been that it has left us with the worst of both worlds. We don't have the benefits of the presidential system because we don't have the friction that is required between the executive and the legislature to make them checks onto each other. But we also don't have the collaboration between, we don't have the accountability that the parliamentary system gives because they collaborate so much that you hold everybody responsible for any failure in the government. So we have ended up with the worst of both worlds. And so the interesting thing is that in spite of this constant consensus, we still haven't been able to do anything about it, which validates the position that the PPP is taking, that it is a question of interest, of will, where the people who must change it are the ones benefiting by it being that way. And so we have a bit of a hostage situation there. I'd like to finally comment before we go for the break on the idea of an independent public prosecutor, which I think that we all realize that there's a gap there. The problem I find is that we are constantly suggesting new institutions. We create more and more institutions. There's always overlaps. And the problem is not the existence of an institution, it is the structure of the institution. As Honorable Fuseni was saying, weak, corrupt institutions will do nothing. We can set up 80 of them. The important thing is to look at how we are setting them up, who we are empowering to supervise the person we are empowering, and how we are populating those offices. Because all of this overlap is resulting in not very much. In the end, if we separate the Attorney General from the Minister of Justice, if the president's appointing both of them, it's the same thing. So we have to think more deeply about institutional structure as opposed to creating institutions and giving them lists of functions or passing more legislation. And I think on that note, I will hand over.
Thank you. Brief comment by Dr. Mame Mensah-Bonsu. And we take a break here, and when we return, she will introduce our next guest.